good afternoon, everybody. You should be being let into the meeting now. So our webinar today is about workplace mediation, when to use it and how it works. So Hannah is driving the slides today. If I just give a little nod to Hannah to change over to the slide, and I'll give us a little introduction to us. So my name is Jo Boxall. I'm a solicitor in the employment team at Harrington Carmichael. And I'm joined today by Hannah King, who is our legal director in the employment team. Hannah is also responsible for our workplace mediation offering that we have at Harrington Carmichael. Now, we mediate on quite a few disputes, but today's webinar is going to focus on workplace mediation, so between an employer and an employee, how it works, what it is, when it should be used, and the benefits of it. So I will be taking the first section of this webinar, and then I'll be passing you over to Hannah on how it works in practice. So to start with, what is workplace mediation? Let me see, thank you. So it is a tool that we use to resolve workplace conflicts or disputes. It can be used at any stage, but it is meant to be used where there is an ongoing working relationship to try and repair that relationship and come to a settlement. So Hannah's going to be going on to discuss the benefits later in this webinar, but in essence, it's really useful as a tool to settle disputes because it's flexible, it's voluntary, and it's confidential. It's managed by a mediator who is the neutral third party in this instance to try and negotiate a settlement. It concentrates on trying to resolve the dispute rather than assign blame to it. So the mediator manages or facilitates that process, like we say, and hopefully tries to get that settlement for both parties. The main benefit of mediation and what gives it its real power is that it's owned by the parties. So the parties can decide exactly how and when the settlement can be discussed and come up with creative solutions to that settlement. The mediator isn't there to make a ruling on the case, nor finding a solution in their own head and trying to push the parties towards it. It is, like I say, owned by them to try and get that resolution. It's also confidential, so it's conducted what we call without prejudice, as many of you will know what that means, but in essence, it's confidential. It cannot be used by either party should the dispute progress into an employment tribunal claim. So nothing should leave the room until the mediator has that party's clear consent to take it to the other side. So the parties need to jointly feel that they can make suggestions or offers or even just vent at the outset. Mediation is meant to be that safe environment to try and resolve that dispute. So it's different to a grievance process, which I'm sure many of you are familiar with. Grievance processes are much more stringent. They're very structured. They follow a defined process. So you will have an investigation, a meeting, and an outcome and an appeal. So it doesn't come to a collaborative conclusion. So the outcome of a grievance, as you know, is determined by the company. It's not without prejudice either. So the idea of a grievance is not to settle a dispute, whereas mediation is. So it can be a little bit less helpful in that sense. It's very different again to the tribunal process. So mediation, as we said, is confidential, whereas a tribunal process is anything but. It can be quite public, and there are certain things that both parties will want to keep confidential. The judge also controls the outcome rather than the parties, so taking away that power that we get from mediation. And if you're at a tribunal, then most likely your relationship between the employer and employee has broken down irreparably. So it can be used for that. Going on to the next slide. So we're then talking about when mediation should be used. So we would recommend it's used at the earliest opportunity to resolve an ongoing workplace dispute. So like we said, whether it's that ongoing relationship. You might use it following grievance outcome to try and facilitate a settlement. It could be used for more sensitive matters. Like we said, it's confidential. So things like sexual harassment, bullying, or mental health absences might be a suitable discussion for mediation to try and settle because both parties want to ensure confidentiality there. It also allows the employee to feel heard. For example, if there are tensions between a manager and employee or communication problems, this is a really useful tool to try and settle that and move forward for both parties. If we then go on to the next slide, I then explain why mediation is sometimes not the right route. So it's not intended to replace or substitute what should be frequent discussions between line managers and direct reports. So, for example, mediation shouldn't be used as an alternative to really difficult performance management discussions. Yes, they're uncomfortable, but it isn't appropriate for that. If an employer doesn't feel comfortable with having that conversation, it should look at things like training for line managers on how to manage those difficult conversations, and conflict resolution. So it shouldn't be used as a way out of those tricky conversations. It also doesn't work where one party is not committed. So mediation only works when all the parties are involved and happy to collaborate to try and reach a resolution. It's also not most appropriate where there is a remedy that cannot be given unless it's through an employment tribunal, for example, or another civil court. For example, if the employer wanted to seek an injunction, mediation cannot get that resolution. So we're then going to talk about when to start mediation. So like we say, the earlier, the better. Timing is everything. If you're leaving things too long, positions can harden, emotions can intensify, and workplace relationships can be irretrievably damaged. So it's best used after an informal conversation. However, if things progress to a grievance and an outcome, like we said, it can be used following that to try and facilitate a settlement. It's meant to be a proactive tool rather than a last resort. It can be used at any stage as well. So you might even have multiple mediations. If the first mediation isn't successful, in the fact it doesn't end up with a binding settlement agreement, that doesn't mean it's not successful generally. The idea of mediation is that both parties get to put their points across and try and settle it. So if you have one mediation, it doesn't mean that there won't be another where you can try and facilitate settlement again. So the role of the mediator. So they are meant to be independent and impartial. They aren't there to decide who is right or wrong. They are neutral. Their role is to help both parties explore issues, communicate more effectively, and ideally agree on a constructive way forward. We're meant to be maintaining impartiality, setting grounds for respectful dialogue, and ensuring confidentiality. Like I said, if a party in particular wants to vent. The emphasis is on repairing that relationship. So, for example, making sure that employee feels heard rather than dwelling on blame itself. So I'm now going to be passing on to Hannah to talk about how mediation actually works in practice.
Thanks, Jo. So I've had the privilege of having attended mediations in the capacity both as a representative for a client who is participating in a mediation in a more litigious setting, but I've also had the privilege of attending mediation as a mediator themselves. So I've kind of had the benefit of seeing both sides of how the mediation processes operate. The focus of this webinar is obviously specifically on workplace mediation. So we're looking really at a mediation process that arises before we get into the stage of litigation. So it's to intervene at those really early stages of a conflict that's arisen at work, to try and resolve it before it escalates and gets more formal. So where mediation has been identified as an option, and that's both parties are willing to engage in that. The first stage would be to decide who you want to appoint as a mediator. Now, it can be somebody internally within your business if they have the knowledge and experience and capabilities of conducting a mediation, or it can be an external third party. And there are pros and cons for both. The benefits of having somebody externally come in and mediate is it maintains that perception and understanding of impartiality, that they don't have that vested interest in an outcome either way. They're coming into it fresh, having not had any previous knowledge or experience of the parties involved in the dispute, and they can come to it with a fresh pair of eyes. Once you've decided on who your mediator is, usually the first step is for the mediator to contact both parties, introduce themselves, and to then ask or request any background information or documentation that might be relevant, just to get an understanding of the situation and what's been going on. That can sometimes involve, having been given perhaps a grievance complaint, if we're looking at a mediation that's arisen as part of a grievance process, and any outcomes, if that's already got that far, or any other relevant information that the parties might want the mediator to see. So that could be, performance reviews or things like that might be relevant. Once that documentation has been obtained, then usually the mediator would just either have a quick phone call or just an initial introduction on email, and just answer any initial questions that either party might have about the process itself. Then we sort of move on to the main mediation on the day. And usually that mediation can take place either at the workplace itself, or if the parties are more comfortable, it can take place at a neutral venue. We have hosted mediations at our offices before, so that's something that we can make available to people, and that sometimes works better because it ensures that confidentiality of the process, and it takes people out of the workplace and on neutral territory, which is sometimes well received as well. So we're on the day, in terms of how the mediation themselves operates, you normally have what's called a joint session initially, where the mediator essentially gets both parties together and understands what either party are looking to achieve, and it's good to get both parties in the room, and it allows each of them the opportunity to make essentially an opening statement. It's really important that both parties respect the process and allow each party to speak and make their point without interruption. Even if they disagree with something that's being said by that person, they will be given their opportunity to speak as well. After those initial statements have been made, the process is really fluid. So there's no hard and fast rules about how and how many meetings should be held, who should speak first, who gets to meet, then have a private discussion with the mediator first. And actually, if both parties in the room together are having a constructive dialogue, then it may be that joint session will continue beyond those opening statements. However, what normally does happen is the parties will then break off into separate rooms, and then the mediator will essentially act as a go-between in respect of those two parties. So in terms of the private discussions, as Joe touched upon, anything that discussed with the mediator during those private sessions is private. So it's the party's opportunity to really be open and honest and frank with the mediator about what the issues are and what resolution they're looking to achieve from that process. Anything that the mediator is allowed to take away, they have to get their express permission of the party involved on to communicate that particular piece of information to the other party, because it's really important that both parties have the understanding that they can trust the mediator with what they want to say, and that only what they give permission to be fed back will be fed back. Now, in workplace mediation settings, when we're looking at what resolution and what people want to achieve, it's not necessarily monetary, and we're not looking at it from that perspective quite often, because we're at a very early stage in the dispute, hopefully, when the mediation comes into play. So it's important for people to think about what it is that they want to achieve, and have that sort of thought process, and have gone through that before you come to the mediation, because it allows the mediator to discuss that with each party, and what's realistic and what can be achieved as part of that process. So the individual meetings are really important, because they allow each party the to have a full and frank discussion about what the issues are, what resolution they want to achieve. And it allows the mediator to then potentially identify areas of common ground where actually, there might be some easy wins that could be ticked off fairly early on in the process, where actually both parties are in agreement on something, and you can then work and build on that. So the sessions are really useful, and essentially what will then happen is the mediator will essentially ferry between the two parties. It can be quite difficult for one person if they're sat there with no contact from the mediator for a period of time, but that's not a reflection on them or the importance of the points that they want to make. It's simply to allow each party the opportunity to, speak and share everything they want to share with the mediator. So there can be periods of time where you're essentially left on your own as a party to the mediation, but that's not to say that the mediator won't come to you and they won't place equal importance on your perspective and your viewpoint as well. In terms of the process itself, as I said, it is fairly fluid, and actually once you've had those initial individual meetings, it might be that there's an opportunity then to bring both parties back together and to then build on a discussion that's more sort of fluid with input from both parties at that time. So although there's sort of broad process and how things will be conducted on the day, there's no set formula for what one mediation will look like compared to another. So really, the purpose of the mediation is for the mediator to listen, to hear what each party wants to achieve, to identify common grounds, and then to get the parties to think themselves about how they can go about reaching that resolution. As Jo mentioned, it's not for the mediator to come in and express a view on, the merits of somebody's complaint, or whether they think that they have a claim that's pursuable or anything like that. They're very much neutral territory to facilitate a discussion and get the parties to think about what do they want to achieve and how in practice do they think that can be achieved through the mediation process. So I've kind of run on a little bit into the next slide. So as I mentioned, the private sessions are those sessions between the two parties which are private. So anything discussed in those meetings is not shared beyond those walls, except where express permission is given to the mediator to do so. And really that does have to happen. There has to be some give and take, because if you just share information with the mediator and don't give permission for any of that to be put to the other party, it's really difficult to kind of facilitate and work out how a resolution might be achieved. But sometimes it is the case that somebody just needs to have a bit of a rant, get it off their chest, and then they can get that out of the way and then think about how they can move forward from it and draw a line over what might have happened historically and think about how things can work going forward. So in terms of the possible outcomes of mediation, they can go on for a long time. Generally speaking, you would normally set aside a day for a mediation from start to finish. And ultimately what you're looking to achieve is some kind of understanding from each party of the views expressed by a colleague, whether or not you agree with it, and a commitment to finding a resolution. Now, as I mentioned, in respect of workplace mediation processes, we're not generally looking at a monetary outcome here. We're looking at probably more behaviourals. So the type of things that typically can arise out of a workplace mediation will be practical changes, such as adjustments to workloads, agreements around communication methods or working arrangements. It can be commitments to behavioural changes, so how people interact with each other moving forwards. Sometimes the outcome is just a better understanding of a party's position, and a reduction in hostility and clarifying misunderstandings. As I said, the outcomes are not set in stone they are very fluid, and one mediation to another will always look fairly differently in terms of the outcomes. It is possible after the mediation has concluded to have it documented in some kind of written action plan or agreement, even if we are looking at an agreement in relation to behavioural changes. And in fact, it's really important sometimes to do that, because it allows both parties to reflect on what they've committed to and agreed to as part of that process and what they're going to work towards doing going forward. It allows people to then be held accountable to that action plan, and provides people such as line managers who might be managing the two employees in disputes, or HR, to have that as a reference point, and allow them to check in and see how the relationship is progressing going forward, particularly if problems resurface. It also allows, parties potentially the organisation, if the agreement does fall by the wayside and people are not honouring it, to then look at whether a more formal process is in fact necessary, because of the mediation hasn't been as successful as would have hoped. And to bear in mind as well that it's not necessary for the mediation to reach an agreement on everything. A partial agreement is sometimes a really useful tool just to narrow the issues between the parties. And even if you can't close off everything, it allows certain issues to be resolved, and then allows the door to remain open to resolve further issues going forwards. Just move on to the next slide. The other thing to bear in mind, as Jo mentioned, is the tribunal process is very defined in terms of what outcomes can and can't be given. So normally it's a finding of unfair dismissal or discrimination, and then a monetary sum as an award. You can't underestimate sometimes the power of an apology, and a lot of times people will say that they just want some kind of acknowledgement or apology for how they've been treated. Well, they won't get that through a tribunal process, and in terms of the private mediations that I've been involved in, that really is a powerful tool to have somebody there to apologise and say, I'm sorry that you felt that way, or that my behaviour had that impact on you. And that can go a long way to then actually finding a resolution on the other issue. So if you are then looking at money and things like that, but you won't be able to get an apology from anybody as part of a tribunal process. And if you can start a mediation process really early on in the employment relationship and dispute when it arises, it gives you an opportunity to kind of dampen things down before they escalate to the extent that people really become entrenched in their positions. And as Jo mentioned, the relationship breaks down irretrievably. So that being said, mediation is not a process that always will achieve a successful outcome, and that's okay. If it fails, an organisation hasn't lost anything in terms of it still has formal processes available to it to then address the ongoing issues that between the employees. It doesn't necessarily mean that it was a wasted effort. People often leave with clearer sense of the issues and the possible outcomes that could be achieved. It also does give the employer some insight into where the employees are at in terms of the relationship, and whether there is scope to try and repair that, or if it is irretrievably broken down, where they would need to look at whether these two people can continue to work together, and whether that's something that needs to be addressed through a more formal route, and potentially whether things like redeployment need to be considered. In terms of the fallback on formal processes, quite often we see mediation being proposed as part of a grievance outcome, but actually it's really useful for it to be proposed before the grievance has been concluded, because once you get the outcome, you essentially get a fairly definitive view from the organisation to an employee that your grievance is either upheld or not upheld or partially upheld. And then the suggestion is, and then let's work towards mediation, by which time the employee could have been made to feel that their point of view is not been valued or taken into account. And it can make actually that process a little difficult. Whereas when the issues first arise, if mediation is proposed at that point, then it allows, a discussion to take place before we've sort of got into the he said, she said too much, and it being documented and bringing other employees into the process and things like that. So it can allow a resolution to be proposed before people get too entrenched in their positions. But if the mediation doesn't work, then there's nothing to say that the employee can't then move forward with a grievance process. And that's obviously always a process that's still available to them. Sometimes people are reluctant to engage in a mediation. One that I was involved in, they didn't want to engage in the mediation process until they'd had their grievance outcome and they knew which aspects of that were going to be upheld or not. And obviously that's the employee's decision if that's what they want to do. You can't force the parties to mediate. As Jo said, it's very much a voluntary process, and both parties have to be willing and wanting to engage in that. Otherwise, there's no point doing it. If somebody feels like they've been forced into it, then you're never generally going to have a very successful outcome. And even if the mediation doesn't succeed, it has allowed both parties to potentially have felt heard, to air their issues, and it might even allow them to sort of have a degree of drawing the line under things and moving on, even if no formal agreement has been reached. It can also be really useful for an organisation because it can allow them to potentially identify systemic issues, things such as workload pressures, unclear policies, poor management practices, and things that need to be addressed at a more organisation and management level. So there are benefits to going through a mediation process, even if ultimately the outcome isn't necessarily an agreement from the two parties involved in that process later down the line. So what are the benefits of mediation? So first of all, it does work. It has the ability to rebuild trust, repair working relationships, and it moves the narrative away from blame or punishment to trying to find a resolution and moving forward. So it's a really useful tool, and it makes the process far more constructive rather than the formal, fairly mandated routes of things like grievances and things like that. It saves time and costs, so it is a quicker process. As I said, there is generally a commitment of a day for these things to reach a conclusion, but that's one day, and the productivity that can then follow having gone through that process and resolved those issues can be immeasurable as well. So having these issues hanging over your staff can cause stress. They can take up management time in having to intervene in those things. So the commitment of a day to a mediation process is not really very much in the grand scheme of things. It is cheaper than litigation. Obviously, if it does reach the stage where the relationship's broken down and claims are looking to be pursued, then the cost of tribunals are not getting any cheaper. The process of tribunals are not getting any quicker. The tribunal system is very much in a state of disarray. Claims are being issued. We're not getting preliminary hearings for claims listed for a year after they're issued, and that's just the preliminary hearing to decide on what the directions and the issues are. The actual final hearings are not being listed potentially for 18 months, 2+ years after the claims are being commenced. So there's not going to be a quick resolution through those processes. ACAS are also struggling. We're seeing that conciliators are not being allocated to ACAS cases before the 6-week conciliation period has expired. So that process is not working in terms of trying to reduce the amount of claims that are being taken forward through the tribunal process. So it really is a useful tool to try and resolve those issues. It gets people talking, so it encourages people to look at what's happened, how the issues have arisen, and agree and propose solutions that come from them. And if those, generally speaking, those solutions are proposed by the people involved in the process, then they're more likely to stick to it. They feel potentially empowered rather than the resentful of having a particular outcome imposed on them. They are confidential. So what is said in the mediation remains private, and it allows sort of a safe space for honesty. And it encourages a workplace culture that values dialogue and respect rather than that blame culture of pointing fingers. And that sort of feeds into the maintaining and repairing of relationships. So ongoing workplace conflict is one of the biggest stresses that employees can have, and we all spend so much time at work. It's really difficult when the work environment is not one that employees are coping with well, and it's creating that stress and resentment. So it supports relationships and retention. If you can resolve those issues, you're less likely to have somebody who's going to be leaving or going off sick linked to workplace disputes. Which is a really useful tool as well. Practical tips then. So as Jo mentioned, mediation is most effective when it happens early on and before conflict escalates. You can have anybody sit in as the mediator, and like I said, you can have the options to use internal or external mediators, but sometimes the perception is external mediators are better for neutrality and to build the trust and confidence of the parties involved in that mediation process. Reduce the risks and costs associated by resolving those issues quickly. So it's really helpful to have managers trained on spotting early signs of conflict, such as poor communication, disengagement, or perhaps workplace cliques forming, and to get them to understand when to step in and when potentially mediation might be a useful tool. Mediation should also be embedded in most organisations' conflict resolution policies. So if it's something you're willing to explore and it's something that you want to make available to your employees, then you really should make that known and communicate that and let your employees know it's when it's available, who to approach, and then what to expect from that process. So it's really important that staff understand that it's voluntary, it's not a quick fix, it's not always going to be the solution, but it's a really useful tool and option available to them if it's something that can restore that relationship and trust between the parties. Then we've obviously just got some time for some questions now, and I saw one that just popped up in the chat. So it says, who initiates the mediation process and who sits on mediation meetings? Now, generally, if we're looking at workplace mediations where you're essentially mediating between two colleagues where an issue may have arisen, generally speaking, it would just be the employees that would attend with the mediator. You wouldn't necessarily need somebody there to sit in with you. If you're looking at a mediation process that's being conducted perhaps in a more litigious setting, then generally speaking, you would have the parties would attend with their representatives. So you would have, and that would be either legal or a personal representative that's supporting you through that process. And as I mentioned, I've attended mediations as a mediator and also as a representative that's accompanied a client to formal mediations. So it does depend on the circumstances and how the mediation arises. Obviously, if there is a disability there or anything like that and somebody needs additional support through the process, then absolutely consideration could and should be given as to whether they need somebody to attend and sit in on that mediation process themselves. Are there any other questions?
I completely agree with that, especially if we're talking about things that are really sensitive, such as sexual harassment, bullying, or mental health issues. It might be more appropriate to consider who joins the employee with that. There was a second limb to that question, which just says, do you need a formal do you need formal training to become a mediator? And I think we can both reply yes.
Well, there are mediation. So there are registers of mediators who have who are registered with specific organisations, such as CEDE as a commonly known one, Centre for Effective Dispute Resolution is one, and there are registers of for people that have gone who have formally qualified as mediators and essentially do that as their profession. That's not always necessary to go, and quite often people will use mediators such as those, perhaps in the litigious settings, where both parties agree to appoint an external mediator, and then the mediation is held at the mediation organisation's offices, for example. But there are courses that you can undertake, and actually, you know, organisations can train their own staff on undertaking mediation. So it's something that we can do. We go into organisations and train people on how to undertake workplace mediations. But where you're looking at it at a very early stage of conflict resolution, and you're looking at it from a relationship or behavioural perspective, then it's something that potentially an organisation can train their own staff in how to tackle those mediations. The only caveat there is that sometimes there is an air of suspicion about how confidential and how impartial a mediator is, where they've come from within the organisation themselves, and that's where perhaps appointing an external third party to manage that mediation would potentially be a better option. Yeah, so sexual harassment in terms of a workplace mediation, that can be difficult, and the circumstances very much will dictate whether it's appropriate or not. In cases of serious allegations of sexual harassment, I can't imagine it would be an appropriate solution to implement a mediation process there, because it would be very difficult to see how two parties could continue to work together. And ultimately, if somebody has committed an act of sexual harassment, generally speaking, we would suggest, you know, in those circumstances, it's very likely that that would be gross misconduct, and I can't imagine a scenario where you would want to continue to employ that person in the workplace in any event. So I think in terms of allegations of sexual harassment, again, as with a lot of these, it will depend on the circumstances as to whether mediation is an appropriate route, but there very much will be some cases where it wouldn't be a recommended course of action to take. What happens if after the mediation, a couple of days, weeks later, one of the parties comes forward that they're still not satisfied? There are a couple of options that are available in those circumstances. So either, and what quite often happens after a mediation process, is the mediator can, with the permission of the company that's organised the mediation, can touch base with the parties and just see how things are going. If one of the parties comes forward and says things still are not working, then either the options will be speak to your HR teams and see if they can sort of understand what the concern is, and if there's any informal action they can take to try and address that and keep the agreement on track in terms of what was agreed at the mediation. There is an option to go back to mediation if both parties think that that would be a worthwhile exercise. Or worst case scenario, they would have to look at potentially implementing potentially a more formal process in terms of a grievance complaint, if everything's sort of gone awry and things are not working out as planned. And like I said, sadly, mediation isn't a foolproof solution for everything, and things can be great for a while, but then people can slip back into bad habits. And I've been that's where a mediation agreement afterwards is fairly useful, because it can see what was agreed between the parties, and that's all documented, and it can allow, you know, HR and line managers to look at that and potentially hold people to account where they might not be upholding their part of the deal. Are there any other questions?
Can't see any more coming in.
No. Well, just for sort of parting words, mediation is very much on the up. It's something that's been looked at more closely as a dispute resolution option. We are seeing tribunals push it as well. So before multi-day hearings, parties are now being required to attend what's called a dispute resolution appointment, which is where essentially a judge acts as a mediator and tries to facilitate a discussion between the parties and achieve some form of settlement, with a view to avoiding, you know, multi-day hearings taking up the tribunal time and resources. So it is very much a tool that is being utilised more throughout the dispute resolution processes, and there is a lot to be said for early intervention and nipping things in the bud before they escalate, because it can avoid the prolonged process of tribunal claims and the time and costs associated with that, particularly where the claims are not coming to final hearings till years down the line, and you know, people will have left organisations and moved on, and parties' memories will, you know, not be what they were. So if there is an option to resolve the issues and avoid the conflict escalating early on, then it's a really good option to give consideration to. Brilliant. Well, if there are any other questions after the event, then obviously do feel free to reach out to myself or Jo. There are contact details on the end there, and we will share the slides after the oh, sorry, there's a question just come in, I think. At the end of the mediations, would you recommend a reconvene to contract on the plan to move forward? So I assume you mean in terms of bringing the parties back in for a joint session, and where so normally that would be the case. So you would look to confirm what the parties have agreed on in the joint session, as sort of summarising at the end. So where you've sort of had your back and forth between the parties, and you've managed to sort of flesh out a broad basis of an agreement, it would then be a good idea to bring the parties back into the room and to have that, you know, formally documented and acknowledged by both parties. That's in the context of where you're looking at, you know, so things like behavioural changes perhaps and things like that. Obviously, where you're looking at a formal settlement, and there's some kind of monetary sum in a settlement agreement and a settlement of potential employment claims, then you would need to have proper advice from a representative in order for that to be documented and binding. But that would be more appropriate in a sort of more litigious scenario, and a mediation taking place in that circumstance, as opposed to a workplace mediation where you're basically looking at a relationship issue that's arisen between two colleagues that you're looking to resolve. Brilliant. Okay, well, thank you so much for your questions, and thank you for joining me and Jo. We've got the QR code at the end there. If you're not already signed up to our mailer, then please do feel free to do so, because we regularly share out content in terms of weekly articles, and we do monthly webinars that you'll get the links and the information to as well. So if you aren't already signed up, then feel free to do so, and Jo and I will be in touch to share the slides. And obviously, if you've got any other questions, feel free to reach out to us as well. Thank you so much.
Thank you.